Court of Malawi. Thank you. I think we can't hear you. We can see you speaking, but we cannot hear you.
Oh, Tendai, I see you have joined. I'm not sure if where you are, you can introduce yourself. I know you are mobile right now.
Good morning. My name is Tendai Mbanje. I'm a project officer in the Expression, Information and Digital Rights Unit at the Center for Human Rights. Thank you so much.
Thank you, Tendai. Bahati.
Hello, hi. My name is Bahati Sosa. I'm a master's student at the Center for Human Rights.
Thank you. All right, what did I skip here? Okay, I think a lot of people are now joining at the same time. Those that haven't introduced themselves, if you could just also introduce yourselves so that we can start. I think we can give it a minute or two. I see Mr. Peter Kandulu.
Hello, Belinda. I think
Yes.
Wesley has joined with the panelist.
Okay. Over to you, Kennedy. Wesley, introduce yourself. I think Kennedy.
Well, thank you so much for having me. My apologies for getting in late. I struggled a bit with the technology. Fortunately, Davina really was very helpful, and I'm finally in. So I'm Wesley Mwafulirwa. I was one of the lawyers in the case, and I'm also a panelist. I'm a Malawian lawyer, human rights lawyer, and I'm currently doing my PhD at the University of Cape Town. Yeah, briefly, that's about me.
Kennedy.
Yes, I can take over now.
Yes.
Okay, good morning, distinguished participants, colleagues, and friends. And I would like to generally call you as proud human rights defenders. On behalf of the organizers, it's my great honor to welcome you to this important webinar. A webinar that focuses on reimagining the digital freedom and expression in Africa. And the webinar in its entirety will be reflecting on the landmark judgment on defamation ruling by the Constitutional Court of Malawi. And I'm your moderator, as earlier been introduced. Today, we gather a decisive moment in Africa and looking more in Africa's democratic journey, where aspects of freedom of expression is very, very important. The digital age, as we see, has radically expanded, and the possibility of free speech that enables citizens, journalists, and activists to speak to the truth of power, to demand accountability, and to participate in public life is really coming in a more unprecedented way. The dynamics keep happening every day as time goes on. But when you look at these challenges, today, it has raised new challenges. For example, on how do we safeguard freedom of expression in the lines of misinformation, online harassment, power defamation, among many others. We're seeing today that the Constitutional Court of Malawi made a landmark decision on defamation. And therefore, to us, it's more than a national milestone. It's a precedent with a very strong continental implication, one that can actually compel us to rethink how African societies should navigate the delicate balance between protecting reputation and upholding constitutional rights on freedom of expression, more so from the digital spaces. This conversation has been organized by the Center for Human Rights as part of the Faculty of Law at the University of Pretoria. The Center for Human Rights is one of Africa's key leading institutions in advancing human rights, democracy, and good governance. Today with us, we have speakers that I would like to give them the opportunity to start straight away. They will be focusing on the key case that has been held by the Constitutional Court of Malawi. That is the case of Joshua Chisa Mbele versus the Director of Public Prosecution and Attorney General of Malawi. The 2025 decision, which was just given this recent July, and we're going to look at the implications of that decision, the relevance vis-a-vis the African human rights system, more so on two resolutions that have been passed by the African Commission on Human and People's Rights. With us today, we have our first speaker, Mr. Redson Edward Kapindu, who is a judge in charge of the High Court, Financial Crimes Division in the High Court of Malawi. He has been a judge since 2013, and is also adjunct professor of law at the University of Malawi, a former visiting professor at the University of Johannesburg, and a senior research fellow at the University of Johannesburg. He holds a diploma in international human rights from Lunds University in Sweden, a diploma in international refugee law from Paleia International University in Spain, a Bachelor of Laws from University of Malawi, and is also a proud alumni of the Center for Human Rights prestigious program of LLM in Human Rights and Democratization in Africa that is held at the University of Pretoria. And he also holds a doctorate of philosophy from the University of Witwatersrand in Johannesburg. You're welcome so much, Mr. Edward. I give you the floor to take us through the preparation. Thank you.
Thank you very much, Kennedy. I must begin by saying that I didn't know I was going to be the first speaker. I thought there was a keynote speaker and then we were going to come in as panelists, but this is fine. One thing that I want to say in advance is just a moment. I think you can see me now.
Yes, please. We can see you.
Right. Okay, so I wanted to say that I would have preferred if the session we are having had come after the full text of the judgment of the court came out, because this decision having been rendered by some of my brother and sister judges, I tried to contact them and see if they have the text of the decision ready, and I think it is not yet out, the text of it. So we will be discussing, I think, based on a very brief summary that they had released, which sort of affects our discussion on the matter. But I think the fact that the Center for Human Rights decided that we should talk about this right away shows the importance of the decision, not only in the Malawian context, but also regionally, I think, as you said, Kennedy, in your opening remarks. And the other thing that I wanted to say, I am glad that Wesley is here with us, and he was counsel in the matter, because he would probably have more details about what was read out in court when the court was delivering its decision. All right, so having said this, I think we since I am now the first speaker, I need to first of all briefly highlight what happened in this case. The background to the case was that the claimant, Mr. Joshua Chisa Mbele, he is, I would describe him as a prominent social media commentator on political and public affairs in Malawi, especially on Facebook. He makes his comments on Facebook. I don't think he does likewise on X, but he comments very widely on public issues in Malawi, political issues on Facebook. So sometime it should have been 2021 or 22, Wesley can confirm, he posted allegations on his social media page, on his Facebook page, suggesting that the then commander of the Malawi Defense Force, General Vincent Nundwe, had corruptly benefited a huge amount of money from, a certain gentleman who is currently being accused of corrupt practices, Mr. Zuneth Sata. It was not true, as it turned out. He apologized quickly on the same page, and he took down the post. But the general was still very aggrieved, and he decided not to sue, but to go and report Mr. Mbele to the police. And, he was arrested on the basis of Section 200 of the Penal Code, which criminalizes defamation, provides for the offense of criminal libel, as it were. So he got arrested, and then when trial was to commence, he raised preliminary objections. And one of the objections that he raised was to say that the very offense that he was being accused of was unconstitutional. And he therefore invited the magistrate, the trial magistrate, to refer the matter to the High Court so that it could then be referred to the Chief Justice, who would certify the case as a constitutional matter. So we have a scheme under our law, Section 9 of the Courts Act, where if a matter is, generally constitutional in nature, the Chief Justice would give a certification.
This is set up as a webinar. So what I'm asking you to do is send her the link that I just sent you. And then
Mr. Enoch, I would ask you to mute yourself. Okay,
right.
Thank you. You can proceed on Honorable Justice.
Yeah, thanks. So under Section 9 of the Courts Act in Malawi, if a matter raises prominent constitutional issues, the judge or the judicial officer presiding over the matter, may refer the matter to the Chief Justice, or should refer the matter to the Chief Justice, who, after going through the issues, if he is satisfied that the matter, is, predominantly raises constitutional issues, he or she certifies the matter as such. And when that happens, then a panel of judges of not less than 3 is constituted. It is a panel of High Court judges. Loosely, you will hear people talking about the Constitutional Court, but we really don't have a Constitutional Court in Malawi. We have the High Court and the Supreme Court of Appeal. So this is, a broader panel of High Court judges that is supposed to decide on this constitutional matter. So the magistrate referred the matter to the High Court because the magistrate felt that he could not refer the matter directly to the Chief Justice, and the High Court, after looking at the matter, indeed agreed with the magistrate, sent the matter to the Chief Justice, and the Chief Justice certified it. So it was certified as a constitutional matter. And this is how the panel of 3 judges of Honorable Justices Dr. Kachale, Fiona Mwale, and Mzondi Mvula was constituted to discuss, to decide on a number of issues relating to the constitutionality of the offense of criminal libel. And the court made it very clear that their decision was squarely to decide on the constitutional question of whether the offense of criminal defamation was constitutional. It was not to decide on whether the remarks that Mr. Mbele had made were indeed defamatory, because they said, that would be up to the trial court to decide, depending on their decision. So they got seized, and after hearing arguments, probably Counsel Mwafulirwa can tell us what the arguments were, but the court made a number of very important decisions. One was to say that the manner in which Section 200 of the Penal Code had been couched was overbroad, and that it was vague, it lacked precision, and it was therefore open to abuse. That basically people can use it as an instrument of suppressing dissent, suppressing critical voices, basically suppressing freedom of expression, which is guaranteed under Section 35 of the Constitution of Malawi. Two, the court also, held the view that criminal penalties, including and especially imprisonment for defamation, were disproportionate to the intended aim sought to be achieved by the statutory scheme, and that they went far beyond the necessity of protecting the reputation of others. The court held that civil remedies are adequate, and that the reputation of others could be sufficiently protected by bringing a civil suit for defamation, which is already part of our statutory regime and the common law that applies in Malawi. It was the court's view that having this offense, as it is in the Penal Code, would have a chilling effect on freedom of expression, and that it would pose a threat generally to those Malawians or the people of Malawi who would seek to express themselves in critique or to criticize powerful public officials in the country, such as the general, in this case, the head of the defense forces. The court also, I also referred to a wide array of case authorities: local, comparative domestic case law from supranational courts and tribunals, and so on. The decision is quite comprehensive in that regard. I thought I could, on my part, point out what I think is a very important feature of this decision. And for me, because there are many aspects of it, we can't talk about everything. I thought I should focus on how the court has relied on principles of public international law, in particular international human rights law, to arrive at the decision that they did. The draft that I saw in Raw, shows that they considered so many instruments, so many case authorities premised on international human rights law. And this is not common. I don't know about, some of the jurisdictions around, but in Malawi, it is not very common to have the richness in terms of the application of international human rights law instruments in a decision. So the UDHR was part of the scheme. They cited Article 19. They cited Article 19 of the International Covenant on Civil and Political Rights, including General Comment number 34 of the Human Rights Committee, which specifically states that states parties should refrain from criminalizing defamation, and that in the event that they do, which the Human Rights Committee discourages them from doing, it says imprisonment should never be a permissible penalty. And the statute, Section 200 of the Penal Code of Malawi, failed on both counts, right? It obviously was criminalizing the offense, which the Human Rights Committee, interpreting Article 19 of the Covenant and Article 19 of the UDHR, said, no, you shouldn't criminalize defamation. Civil suits should be a sufficient remedy. But if you do, don't have prison terms. And Section 200, raises the possibility of imprisonment. So the court, agreed with the Human Rights Committee on that score, and decided that this offense was overbroad. They looked at the African Commission's Declaration of Principles on Freedom of Expression in Africa of 2002. I think it was revised in 2019. Again, that declaration calls on states to repeal criminal defamation laws and to use civil remedies instead. They, went into a discussion on that declaration, cited a number of cases, including the case of Lohe Issa Konate versus Burkina Faso, which, interestingly, and this is an interesting point for me, in their decision, they regarded it as binding, as legally binding. Ordinarily, decisions both from comparative domestic case law as well as from international tribunals are regarded as merely persuasive in our legal system. I am keen to see, because I haven't seen the reasoning yet, I am keen to see how the court arrived at that rather radical position that a decision of in our legal system, which is dualist in character, that a decision of a supranational a court like the African Court on Human and People's Rights is not just persuasive, but that it is binding on Malawian courts. I thought that is a rather, a radical position that the court has taken. I am not entirely sure whether, whether everyone will agree with it, but for me, it is an important proposition, and it has been made, unless the Supreme Court of Appeal, at some point perhaps reverses that position. It is a legal position in this country that decisions from the African Court on Human and People's Rights are binding in Malawi. I think it will make very interesting jurisprudence going forward, based on that position. The court looked at some decisions from the ECOWAS court, and many other decisions. So as I said, for me, the fact that the court relied so heavily on international human rights law, including case law and instruments, and in particular, the proposition that the court made that the decision of the African Court on Human and People's Rights in Issa Konate versus Burkina Faso is binding, is a far-reaching proposition. And for me, a very important proposition, which, however, I must add, I think is likely to face some significant critique, both from scholars and practitioners in the country, in my view. The court also looked at some jurisdictions where decisions had been arrived at by courts to retain criminal defamation. The state raised that to say, well, there are some established democracies, the UK, Botswana, India, etc., that have grappled with this question of the of whether criminal defamation is unconstitutional, and they have said it is a legitimate offense to be on the statute book. But the court, again, taking us back to the international human rights law regime that I just referenced, the court emphasized that those decisions did not sufficiently engage with international human rights instruments, and in particular, making reference to the Botswana case, that there was no sufficient or sufficient engagement with the country's obligations under the African Charter on Human and People's Rights, and to that effect, that the court was not persuaded, therefore, to follow their approach. The court was of the view that it should lean firmly in favor of the predominant position at international human rights law. So for me, that is a critical strength of that decision. You know, I would say, like, you know, Dawkins would say that, you know, the court demonstrates here that it took rights seriously, you know, emphasizing that, you know, rights are really trumps against you know, some you know, communitarian positions that the state was advancing. You know, basically saying that it is in the public interest that we should have you know, criminal defamation, and the court emphasizes the centrality of individual fundamental rights and that they must be given full effect. So for me, I would say, look, this is a clear case of, if we are to put it in philosophical terms, we would agree with what Dawkins said, that we need to take rights seriously. And, you know, I would stop there to say that for me, I would summarize this decision in that way, that it is a decision that takes freedom of expression seriously. Freedom of expression as guaranteed under Section 35 of the Constitution of Malawi, freedom of expression as guaranteed under, you know, the Common Article 19, and under the African Charter on Human and People's Rights, among other instruments that we could cite. So I think I can stop there, and probably the rest we can take it during.
Thank you so much. Thank you so much, Honorable Justice, for your insights, and you've laid a very strong background to the case and the impact of that case. I would like to refer you back to your to a 2019 publication by you yourself. The publication is titled Malawi Legal System and Research Sources. In that publication, you very reiterated the legal system of Malawi. And you emphasized the application of common law, and you looked at the provision of Section 200 of the Malawian Constitution, in which you very stated that Malawi still continues to apply the common law system. So I would like to take you back to that provision that allows Malawi to apply the common law system in itself and apply to this case. You see very well, it's clear that the court by its nature in applying common law works on tort. And under tort law works on defamation in two ways, either granting it as a libel or as a slander. And when somebody is aggrieved or someone feels defamed or his reputation has been lowered by communication by somebody, the person has two ways: to proceed civilly, which is tort law, which means the person is going to get compensation and so forth. And on the other hand, if someone decides to proceed criminally, which has just been outlawed by the Constitutional Court of Malawi under Section 200, which no longer allows the criminal aspect of it. That doesn't mean a person now in the Malawian circumstance not allowed. You don't have a two-way remedy. You only have a one-way remedy, which is a civil remedy. Now, my question in that regard gets to, how do we strike the balance between this, especially with the growing digital space where harm can quickly spread? In line of your presentation as well, should African states move towards a purely civil remedy for defamation, or is there still a legitimate case where some criminal sanctions can stand? For example, assume out of a defamatory statement, it leads to a gross violation of human rights for a white population. Should the criminal aspect of it still be there? I would like to engage your inquiry in that as well.
Well, I just want to focus on your last statement where you're saying that if defamatory words or libelous words, affect the rights of a wider, population group, shouldn't that be criminalized? And I'm trying to think how this will happen, because defamation is individualized. You are talking about the reputation of a particular individual, right? And I think what the courts are saying is that if you weigh the benefits of criminalizing against, the negatives that criminalization would bring, there is so much negative out of criminalization, in the sense that you are going to generally suppress free expression of people, and in particular, most of the people who like invoking this offense are, people with a name, with a public name, people who frequently are public officials who bring this offense up, and that it will have the effect of suppressing free expression. Now, the instance that you explained about what if it affects a wide sector of the population, for me, I think the words that may cause harm to a bigger sector of the population are in all probability going to be categorized in the category of hate speech. And this decision does not say that a person cannot be held criminally accountable for hate speech. That's a different matter. So it is going beyond, mere defamation, where you are saying, oh, well, what you said about me is not true, right? Because in essence, stripped to its essentials, that's what defamation is about. That someone is complaining that someone has published information about him or her, which is not true, right? But if the content of that information goes beyond simply saying something that is untrue about a particular individual, but it then delves into the domain of hate speech, and it now causes harm to so many people who hear these offending words, the High Court has not said that that should not constitute a crime. So I hope that puts the decision, at least as I understand it, and I should add that I haven't read the full text. So but as I understand the decision so far, this is my understanding, that it is looking at the particular circumstances of a particular individual who feels aggrieved that his or her reputation has been harmed, and it does not go beyond to the scenario where the people that are offended by those words are so many. And in my view, that would only, we should be mindful of what the Handyside case said about the scope of freedom of expression, right? So basically, people must have a thick skin, to handle words that might be offensive, even, right? But where it delves into the domain of hate speech and so on, then that can still be criminalized, in my view. That's my understanding, and that would be my view.
I think you left out some. You left out on this. The question also focused on is there still a legitimate case or a legitimate circumstance under which some form of defamation would have a criminal sanction? Are there some instances, if given that you are a judge in this case, would there be an instance where you would have a leeway for certain cases where defamation would call for a criminal sanction?
Not in my worldview.
Okay.
Not in my
Okay.
will. I am a proponent of the position that criminal defamation should actually be declared. I mean, if I was on the panel, I was going to be of the same view. And I was not going to make an exception. The only exception that I would make is those general exceptions that we would have in respect of freedom of expression that are, recognized under international law, like the instance that I was just giving you. But in terms of criminalizing defamation, and from experience, because we have seen so many people. I don't know about some of your jurisdictions, but we have seen so many instances here where people have been prosecuted for the offense of criminal libel. And in probably over 80%, even maybe 90% of those cases, it is politicians complaining against citizens about their reputations. So for me, it is an offense which, I mean, even if we were to move aside from the conceptual to the practical, it is an offense that really has been used so much by public officials and in particular politicians to suppress critical voices against themselves. And I don't think that it is an offense in that regard that we should maintain on our statute books. So that would be my, as I sound, strong view.
Thank you so much, Honorable Justice, for your insight. I also beg the participants who have just joined us, you can go to the comments and let us know who you are and the organization you are, and the institution you are. I've been reliably informed that we have been joined by the Honorable Commissioner who has given us a time to come and be part of us. Thank you so much, Honorable, for joining us. We have just heard from Honorable Justice Kapindu, who has given us a very elaborate insight on the case, the background, and he has also taken time to respond to some questions. And to the participants following his presentations, you can also note down some of the questions. In the Q&A sessions, you'll be given an opportunity to ask Honorable Justice so that you get more insights from him following this case. With us, we are privileged to have been joined by Honorable Commissioner Geereesha, who should have given us the keynote address earlier on, and I think would give her the opportunity to do that now that she has joined. Thank you so much for joining us. I would like to give a brief about her. She's a national of Mauritius and was elected as a member of the African Commission on Human and People's Rights in 2021, and she was sworn into office on the 15th of November 2021. She's a special rapporteur on the freedom of expression and access to information in Africa, a vice chairperson of the Working Group of Extractive Industries, Environment and Human Rights Violation in Africa, member of the Working Group on the Death Penalty, Extrajudicial, Summary or Arbitrary Killing and Enforced Disappearance in Africa, and a member of the Resolution Committee. She's a lawyer with great expertise in international maritime law, and she currently works as a parliamentary counsel in the Attorney General's office. Her areas of experience includes presenting the state in court cases, tendering advice to various ministries, and drafting legislations. Honorable Commission will give us her keynote address. The Center for Human Rights also acknowledges her contribution to always being part of the webinars and offering her insights and for the practical understanding on these areas in Africa. You're welcome, Honorable Commission.
Thank you very much. So thank you. Good morning, everyone. I'd like, first of all, to thank the Center for Human Rights of the University of Pretoria for having organized this webinar. So at the outset, let me say that I am very, very happy with that judgment of the Constitutional Court of Malawi in the case of Joshua Chisa Mbele against the DPP and the Attorney General, which I think was handed over in July 2025. So what the Constitutional Court effectively did was that it declared that Section 200 of the Penal Code of Malawi to be unconstitutional. So that is a great thing for freedom of expression in Africa. And I think that the provision of Section 200 of the Penal Code reads that any person who by print, writing, painting, effigy, or by any means otherwise than solely by gestures, spoken words, or other sounds, unlawfully publishes any defamatory matter concerning any person with intent to defame that other person shall be guilty of a misdemeanor labeled as libel. So the court effectively said that criminal defamation does not find its place in and is contrary to Section 35 of the Constitution of Malawi. And I think that the African Commission on Human and People's Rights, more particularly my mandate, the Special Rapporteur of Freedom of Expression and Access to Information, we are very happy with this outcome. And every time that the state comes to present its report to the African Commission on Human and People's Rights, we always bring to the attention of the state that, in fact, criminalizing defamation is wrong. It is contrary to freedom of expression and access to information. You can have a civil case, and I think the discussion before I joined in was whether in any case there can, in any circumstance, there can be criminal defamation. My answer to that is no. There can be no case where you can have criminal defamation. And we invite all states to strike out any law that criminalizes defamation. You can have a civil case that is entered into, but there cannot be any circumstance that justifies criminal defamation. And as has rightly been pointed out by Justice before me, who was intervening, these criminal defamations are used by state parties and other state actors to just clamp down on freedom of expression and clamp down on people who are against those in power. So, as rightly pointed out as well, the Declaration of Principles of the African Commission on Human and People's Rights of 2019 states that there has to be decriminalization. And therefore, in light with, let me just say that there are certain resolutions that the Commission has just passed. That is Resolution 620, 630, and 631 of 2024 and 25, as well as 639 of 2025, which aim to promote public interest content in the digital spaces, strengthen information integrity through independent fact-checking, as well as encourage human rights impact assessment by platforms and other technological companies, as well as ensuring freedom of expression that is protected amidst digital regulation. Therefore, in light of all these resolutions that we are passing, and with which we will be issuing guidelines soon that will hopefully be adopted by the Commission, we are very happy with this judgment. And I think we have, I have personally already written to the government of Malawi to congratulate them for this very powerful and very positive outcome for freedom of expression and access to information. Thank you.
Thank you so much, Honorable Commission, for your wonderful and elaborate keynote address. The keynote address aligns with also our aspiration as human rights defenders, who've also worked hard to see that cases like defamation are decriminalized. This means we are on the same boat as human rights defenders, trying to push forward to the freedom of expression in Africa. Thank you so much for your presentation once again. Our follow-up questions may come up to you later on by the participants. All right, thank you so much. With us again, please, those of us who have joined, feel free to flag the comments and then get more with your name and the station that you're from, and also to keep this debate going on. I also believe the social media spaces also helps us to discern this information far and far, so such debates can also keep going on in our social media pages like the Facebook, Instagram, and so forth. All right, here with us again, we have our third speaker, Mr. Wesley Chalo, who has been also a lead counsel in this case. Mr. Wesley is a Malawian human rights lawyer and scholar. He's the senior partner at John Tennyson, Kawelo and Associate, where he also heads the Constitutional Law, Human Rights and Public Interest Litigation Department of the firm. He has been instrumental in a number of domestic public interest litigation cases, as well as on matters pending before the African Court on Human and People's Rights. West also teaches law at Mzuzu University, and his main teaching and research interest is around the internationality between human rights and digitalization. Wesley is a postgraduate teaching assistant at the University of Cape Town, Faculty of Law. Wesley holds a Bachelor of Laws at the University of Malawi and a Master of Arts from the National Anti-Corruption Academy in Austria, and he also holds a PhD in Public Law at the University of Cape Town. His research areas for the PhD examines to what extent the Malawian e-government regulatory framework is an enabler or a barrier for e-participation. So we are here with the expert, one of the public interest litigants that push forward to this case, as has been referred on by the Honorable Justice. The floor is yours, Mr. Wesley.
Thank you so much, Mr. Owor. I hope I've pronounced your name correctly. I will turn on. Okay. I will turn on the camera just for a few minutes so that at least you see me. And
or in case you have your presentations, you're also free to share it on the screen.
Okay. Well. Yeah. Unfortunately, I think my video camera is not working. So just one small correction. I do not hold a PhD, not yet. But I'm reading towards my PhD, but I don't hold a PhD, not yet. But indeed, I'm a PhD scholar at the University of Cape Town, where I also work as a teaching assistant, and I'm on contract also lecturing one course. Now, indeed, I was part of the team, the legal team that prosecuted the constitutional challenge. And as the Honorable Justice Kapindu said, we don't have, in Malawi, we don't have a constitutional court in the strict sense of that word, as we have it here in South Africa, where you've got a proper constitutional court. What we have in Malawi is a high court that is sometimes empaneled by the Chief Justice to hear a constitutional matter. And because it's a high court, you can actually appeal against the decision before the Supreme Court, which again is a very, for most South African lawyers, they find that to be a very strange concept. Now, what happened in terms of the factual background, I would say the judge again has just set it out very well to say there was a matter, our client was charged under the impunged section 200 of the Penal Code, as well as under the other charge was under Section 86 of the Electronic Transaction and Cyber Security Act of Malawi. When our client was charged, what we thought after, discussing with him, we thought, well, he had a very good case to challenge the constitutionality of Section 200 of the Constitution vis-a-vis the right to his right to freedom of expression. And indeed, we started the process. We applied for a stay and the Magistrate Court. The matter went before the High Court, before Justice Ntalimanja. And then, of course, the judge did refer the matter to the Chief Justice and stayed the criminal proceedings. But then that decision was challenged by the Attorney General. We went to before the Supreme Court. It was challenged before there was an appeal against that decision. We went before the Supreme Court, and we did win that round. So we had a good decision from the Supreme Court by Justice Ivy Kamanga, who held that, who found that we had a good case, our client had a good case, a good constitutional challenge against Section 200 of the Constitution, and then the matter went back to before the Constitutional Court. Now, if you go online on Malawi, you find these two decisions. So you find the decision of Justice Ntali Manja, which discusses the issues of around constitutionality of criminal defamation and what human rights, the international human rights say. You find it there. You also find a decision by the Supreme Court, a single member of the Supreme Court also around the issues. Now, this year should be on the 28th of January. Me and my colleague, Counsel Gilbert Konyongwa, we appeared before a full panel of the Constitutional Court. Unfortunately, my colleague could not join me because my colleague is vying for a political position as a member of parliament. So we've got elections next month, and he's very busy campaigning, but he told me that he really wished he could join us, but unfortunately he is busy on the ground campaigning. So me and my colleague, we proceeded to argue the case on behalf of our client, and my lord, the Justice Kapindu has summarized the arguments very well, but I just want to also point out that when we set out to argue our case, we honestly thought that our arguments would be straightforward. We're going to cite the declaration and the treaties, the general comments, and we had cases, one of which my Lord Chief Justice mentioned, the Konate case, and so on and so forth. We thought our case was very straightforward until we started doing deep research into the other cases and the counter arguments. We realized that even within the African continent, we have a few decisions that were not in favor of our client's argument. So, for example, in Uganda, the court in Uganda held that criminal defamation is constitutional. There's also another case, if I'm not mistaken, from Seychelles. There's an old South African case as well. And we all look up to South Africa as being the benchmark for for human rights compliance. And we thought, okay, wow, we thought our case would be straightforward, but then when we started finding all these decisions, the South African case, the Ugandan case, I think the one from Seychelles, and then we also found a few decisions from India. But then still, we managed to also identify a lot more cases that held that criminal defamation cannot be justified under human rights law. So there were quite a few, actually more cases aligned with our argument than those which did not align with our arguments. But also, I think the key point that we found out was that most of the cases that held that criminal defamation was all right did not properly discuss the international human rights instruments that Malawi is party to. So we did make our argument before the court, and I also must mention that we managed to work with a few organizations and colleagues who I think it is only fair that I acknowledge their effort. So, for example, we worked with a Media Defense, an international organization based in the UK, and I am an alumna of their litigation surgery on freedom of expression. Also worked with the Southern African Litigation Center, who also gave us the technical as well as financial support. Counsel Chikondi Chijozi from the Human Rights Commission, Malawi Human Rights Commission, was also very instrumental and helped us. Also, the Paradigm Shift, the Paradigm Initiative, they also helped us with technical support, and so many other colleagues who, some of them have not given me their permission to name them, but otherwise we got so much support. And my supervisor, also my PhD supervisor, Professor Donald Chirwa, was also very instrumental. And for me, it was interesting that the central argument that we were making in the case is part of the argument that I'm making in my PhD research. So it was interesting that, most people will tell you that PhDs or theoretical, academics and scholars, we just make theoretical arguments. But I feel like I argued a case that revolved around my PhD thesis. So that was also quite interesting. And then a month or so ago, the decision was handed down, and the full decision, the final decision is not yet out, but the summary, which is about 2 pages, is out. And basically, I think my lord also, the judge, Justice Kapindu, just will summarize what the court said. By way of clarification, I think there was there's a question that Ms. Owor also raised to the judge on defamation and if it affects the larger group and so on and so forth. That's also one of the arguments that actually the state raised in the case. And in fact, one of the issues was, what about hate crimes and so on and so forth? You may wish to note that if you go to Article 20, for example, of the ICCPR, propaganda for advocacy for national, racial, religious hatred, or incitement of discrimination or hostility or violence, they are all legitimate aims of limiting freedom of expression. So under Article 20 of the ICCPR. And also if you read General Comment number 34, it's very clear. So hate crimes are very different from defamation, because remember, defamation, the emphasis is just on reputation. So someone's reputation. And also just to point out, like the other question that was raised about, with digitalization, reputational damage has been made very easy. So don't we need criminal penal defamation in our statutes? That was also one of the issues that was raised by the state. But then we counter argue to say, look, most of the digital or cyber offenses are already covered under our laws. So we've got a law, it's called the Electronic Transaction and the Cyber Security Act. Of course, if you ask me, I have problems also with the way some of those provisions are couched under our act. In fact, it's an argument I'm making in my PhD thesis. I'm arguing to say that the way the act was couched is overly broad, and it's been actually weaponized to stifle freedom of expression online. It's one of the arguments that I'm making in my PhD thesis. And I know the follow-up question would be, okay, since your client was charged under both the Penal Code as well as the Cyber Security Act, the Electronic Transaction and Cyber Security, I'll just refer to it as the Cyber Security Act. Why is it that your client only challenged the constitutionality of Section 200 and not the constitutionality of the other provision that he was charged under? My view is that both provisions are problematic if you scrutinize them under the lenses of our Constitution. However, there's a reason we call it strategic public interest litigation. The strategy. So our strategy, we knew, and we were of the view, and I still am of the view now, that we are better off going for the low-hanging fruit. And in this case, Section 200 was low-hanging fruit. It would have been as strategic for us to go for both. But I'm sure in the future, once this judgment is out, other claimants or potential claimants would also go for even a challenging constitutionality of some of the provisions of under the Cyber Security Act. As again, the judge rightly mentioned, what you notice is that most of the people who are arrested or citizens who are arrested for publications under even both the Penal Code as well as the Cyber Security Act, most of them, they'll be targeted for political speech, but not necessarily, private conversations. Although there's a paper that I submitted for publication, and it may be out very soon, where we analyzed, me and my colleague Salome Ndala, we analyzed the arrests that have been made for political speech in Malawi, even under the Cyber Security Act. What we notice is that, either there'll be political connotations to statements that are made online, or yeah, or there will be a connections. It will be connected to highly, like the people who are very rich or elites. So there is that also elitistic aspect to a prosecution of these offenses. You hardly hear of someone who is low in terms of the socio-economic statuses of Malawi, who has lodged a criminal complaint in because of something that was said online. So we are also looking at all those aspects, and we make an argument in that paper that will be published very soon, because it has been approved by the reviewers for publication. One of the arguments that we're making there is that most of these offenses that deal with speech online, they represent a weaponization of the law to steal for free speech generally. Having said that, our client was very happy with the outcome, and our hope is that the outcome of this case is going to shape the jurisprudence on freedom of expression, both online and offline, in the region, and as well as beyond the continent. Thank you so much for your attention.
Thank you so much. Thank you so much, Wesley, for your elaborate presentation. You've really shot at the big elephant that we wanted to hear. I understand many questions would come to you. I want to agree that you were at the forefront of this landmark case that led to defamation. A ruling that now to us in Africa stands as a beacon of freedom for expression, and that can set example for other countries to follow. And to us in the human rights space, cross-collaboration is one of the strongest elements that we have that makes our work easy. Could you, in line of your response to this question, walk us through the key elements or the strategies of your litigation strategy? And more importantly, how do you think this strategy can inspire or be adopted by lawyers and civil society organized actors in other African countries that are facing similar struggles against criminal defamation and digital repression? So in line of your response, how can such strategies that you as the lawyers in Malawi adopted encourage a cross-sectional collaboration with other bodies of litigants across Africa to promote rights-based digital governance?
Thank you so much, Owor. That's a very good question, I must say. So for me, I remember, I think it must have been in 2016. I attended a training by the Southern African Litigation Center. It was in Johannesburg, on how to conduct strategic public interest litigation. So one of the issues that was said at that training, and it's always stuck with me, is that with strategic public interest litigation, the impact of your case is not just on the parties to the case. So the ultimate impact of that case may go, and in all cases actually it goes beyond, the impact goes beyond the parties to the case. Now, bearing that in mind, one of the strategies that I always do, or I always use in all the cases that I do, which involve PIL, public interest litigation, is never to look at my client's personal interest or just my personal interest, but to look beyond my client's interest and, as much as possible, see how I can collaborate with other lawyers and institutions. And I know this is always very hard for lawyers because, somehow I don't know, maybe the nature of our training gives us a very big ego. We want to be the one seen to win the case and so on and so forth. But always remember, always bear at the back of your mind that the impact of your case will go beyond your claimants. Now, that goes both ways. It's like a double-edged sword. When you lose, it was going to affect your clients and also other clients, even beyond your country jurisdiction. So as I mentioned, for example, one of the hardest part for us to argue the case was when we realized that there were cases in other jurisdictions where the court said criminal defamation is okay. It meets international human rights standards. Okay, so collaboration is very important. Now, how do you do that? It starts with the training, I must say. So, for example, at the center, I've attended a few trainings from the center as well on digital rights. I did attend one in, when was that? That must be in 2018 or 2019. So I did attend a few trainings on digital rights at the Center for Human Rights. And through those trainings, you start appreciating why you need collaboration. I've attended a few trainings in my country and outside of my country on strategic litigation and how you can collaborate. And as I also mentioned, I'm an alumna of the litigation surgery on freedom of speech by the media defense. So again, it was a litigation surgery that we had in Johannesburg. And through those litigation surgeries, I learned how to collaborate with organizations and other lawyers and so on and so forth. So it was very easy for me to collaborate. In fact, even the way I got looped in the case, I saw the case in the newspaper that there's this case, and I simply called the lawyer who was handling the case. I said, "Counsel, I'm happy to join you pro bono. You don't have to pay me anything." And he was like, "Are you sure?" I said, "Yeah, I'm happy to join you. Look, it's part of my PhD arguments and so on and so forth. I'll give you get consent from your client." And the counsel Konyongo spoke with the client. The client was happy for me to come in and join the case, and that's how I joined the case. And yeah, so collaboration is very key. And also in the course of collaborating, what you realize is, and I think just to encourage lawyers to learn to work together, what you realize is that when you work as a team, you have different strengths and weaknesses. Your colleague may be stronger than you in one aspect, and you may be weaker than your colleague in the other aspect, or stronger than your colleague in another aspect. And when you work together as a team, it's very easy for you to to have the perfect strategy. But there are so many things that we worked on in terms of strategy. If I had the time, I would have elaborated, but I'm looking at the time. Maybe I don't have enough time to expound on some of the strategies that we had. But I think in future, maybe if there is another such occasion, I will happily expound on some of the strategies that we worked on. But collaboration is very important. Within the digital space, I can tell you there are several organizations that are more than happy to collaborate. And I can tell you, for example, a very good example is Media Defense. They are always happy and willing to collaborate on matters like this. They will give you financial and technical support. So they have got experts who help you even draft documents, give you the cases, case authorities, and so on and so forth. Likewise, the Southern African Litigation Center is more than happy and willing to collaborate. They also provide financial and technical support on cases like this. And there are several other academics and litigation lawyers out there who are more than happy to collaborate on matters that deal with freedom of expression and access to information.
Thank you so much. I know more questions are still coming for you in lines of our engagements. I do understand when looking at rights, we balance two issues. Rights holder, the person who the wrong has been done to as well. All of them must be taken care of when we're looking at the question of justice. So my question to you gets on the point of balancing the rights, because when you look at you've referred to in your presentation, you've mentioned judgments from Uganda, how the courts of Uganda have also said no, they criminalize defamation, which is also very clear under our penal codes law in Uganda. Arguments flowing from those people are always that decriminalizing defamation leaves a reputational harm that is unchecked. that's some of the arguments some of those people have used to justify why they criminalize defamation. So in your line of thought, how do you respond to the concerns that civil remedies may in their arguments be insufficient in societies where reputational harms have destroyed livelihood, especially in this digital age? How do you see this? How do you see the striking the balance of those rights?
Okay, thank you so much for the question. Yeah, so yeah, a very legitimate question, I must say. To say, okay, how then do we strike the balance in terms of reputation damage vis-a-vis the reputation damage vis-a-vis freedom of expression? And also maybe just to go a little bit further with your argument, remember when it comes to issues of reputation, it also hinges on the question of the right to dignity. So one of the arguments that has been proffered is, well, look, my reputation is also deals with my right to dignity. However, my view, and this is the argument that our client was made, and I think I'm inclined to agree with my client's argument, which we made on his behalf before the court, is there are normative tools that have been set in terms of limitation and striking that equilibrium. Okay, so we've got the normative tools that are there that have been structured to strike, and then they help us to say, okay, how do we strike these balances or the equilibrium? In my view, the equilibrium that has been struck, so and I think as the judge also already mentioned, is if you read, for example, General Comment number 34, if you read the declaration by the African Commission, and so on and so forth, the number one balance is if at all it gets to a position where you can't avoid it and you must criminalize defamation, then sending someone to jail for what they said is, and remember, it's not just what they said, but what they said is only problematic with reference to someone's reputation. It's got nothing to do with hate. It's got nothing to do with inciting violence, but it's just someone's that what was said impacted or affected another person's reputation. Then you can never send a person to jail for that. Okay, so there should never be imprisonment for what someone said or for defamation. So that's standard number one. Okay, that's a normative standard that is there. Okay, in Malawian case, it was a misdemeanor under Section 200, meaning you could go to jail up to 3 or 5 years? 3 years, I think, under the penal code. Okay, so already that standard was not met. Then the other issue is, okay, you also have to restrict this, like you must be used under very exceptional circumstances. So the other argument that we are making is, if you read our Section 200, it doesn't give, of course it was amended, I must say, it was amended, I think around 2010 or thereabout, to try to fit in those exceptions. So there were some exceptions that were created, but still, we are saying even under those exceptions, it was still too broad, and the balance was even struck properly, and this could have easily been abused. And indeed, the statistics show that these provisions were being abused by politicians and the elites to send people to jail. And so for us, still, our argument remains, and I still am of the view that you cannot justify striking the balance of reputation damage by sending someone to jail for violating someone's reputation damage. That's I think that's the point and the balance that we try to the court is trying to strike. Yeah.
Thank you so much, Wesley, for your elaborate presentation. I know the participants can't wait to ask you more questions on the strategies you've used and how this can take the African human rights system discourse far. To our panelists, I know there have been a lot of conversations going on. The Honorable Justice started, the Honorable Commission followed, and then our council followed. I know there may be a comeback from either of you whom you may want to you may want to say something more before I open up the floor for participants to either supplement on their thoughts or ask further questions. I would like to start with the Honorable Justice, if there's anything more else to following the presentations that have been made by the other panelists. Honorable Justice Kapindu, are you still around? Are you still with us? Oh, I think okay. Maybe I would give the floor to the Honorable Commission once again. Okay, I think maybe they'll, yes, Honorable Justice, I see you're back online.
Yes, I just missed your question.
No, I was like, wonderful presentations have been made by the Honorable Commissioner following you, and then also Council, also Wesley came and made a very elaborate presentation. From your line of conversation, is there more thoughts you want to share before we open up the floor to the participants?
No, I think we can open the floor so that we can take as many questions probably as possible.
Fine. With that, then I would like to open up the floor to the participants. Maybe you can simply raise up your hand, and I'll be able to pick you up from our esteemed participants that are in this meeting. Anybody? Let me check the participant panel and see if there's anybody. Okay, I'll maybe give them a minute or so if anybody has a thought or a question to our panelist. It seems the participants are very, very, very satisfied and informed with the presentation from the panelists, from the panel. Maybe I would also like to take back this question to Wesley, maybe to set the Q&A session rolling. Wesley, are we still together? Are you with me?
Yes, I'm still here. Or
yes, Wesley, I do understand very well the impact of the judgment. There are circumstances where courts do make consequential orders. Because, for example, I've seen in your line of choosing your parties, I believe you've chosen the rightful parties that such consequential orders should go through. I've seen you've added the director of public prosecution in the petition. That means they are the very implementers of Section 200 of the Penal Codes Act in lines of framing charges, and as well as the Attorney General. I do understand when a very landmark judgment of this nature is made, it has impact. But as you understand, the law does not, the law applies retroactively. That means those who have been either charged under the provision of 200 of the Penal Codes Act of Malawi, some may have pending charges, or some are pending judgments, or some cases before the court may be pending judgment writings on the nature of charges that have been pursued against those under Section 200. So what is the impact of those judgments, more specifically on those whose prosecution is pending?
Okay, so the court made it very clear that for all the cases that whose prosecution is pending, all of them must be dropped off. So also, yeah, so in simple terms, all the cases that were pending were they are nullity pretty much. They are nullity. That was made very clear actually by the court. Yeah.
Okay. Oh, thank you so much. Our dear participants, please utilize the opportunity to ask questions to our experts. All right, I do believe our participants have and they have really understood the context of this judgment, and I believe they are going to be our ambassadors tomorrow, ensuring that the information of this nature gets into different law schools and institutions, and we'll be happy to see the impact of this judgment moving like a wildfire across Africa to ensure that most African penal courts actually decriminalizes this. So I'll open the floor to our panelists to give the participants their final thoughts. I'll start with Honorable Justice. Can you give us your final thoughts on this?
Well, I do not have much to say apart from reaffirming what I said earlier, that it is my considered view that this is a great judgment. It is my considered view that the judges, you know, got it right on basically all the issues, all the constitutional issues that were brought before them. It is important, I think, that as, you know, African jurisdictions, we need a cross-pollination of jurisprudential ideas. One of the critiques, this goes to my South African brothers and sisters, is to say, and I'm just making a general comment here, that many people say that whilst the rest of the continent is, you know, citing South African jurisprudence, you rarely find South African courts, including the Constitutional Court of South Africa, citing, you know, jurisprudence from the broader continent. You, in many cases, will find reference to jurisprudence from far-off countries in the West, in the US, and rarely will you find you know, those South African courts citing a Zambian decision, a Malawian decision, and so on. But this is just to encourage all of us that it is important that we should have this, you know, cross-pollination, cross-fertilization of jurisprudence on the continent when it comes to matters of human rights. Human rights are universal, as we know, indivisible, interdependent, and so on. And so is our jurisprudence. We should treat our jurisprudence as interdependent, as interconnected, and so on. Because at the end of the day, we are dealing with one settled, you know, universal regime of international human rights. But a very good decision, and I should commend Counsel Mwafulirwa and you know, and his colleague for having argued this case very well, and they have given the court the opportunity to give us this lucid decision that provokes thought, but at the same time also lays the law very clearly insofar as the Malawian human rights landscape is concerned, and hopefully will have an impact on the broader continent. So thank you very much for inviting me. I think I didn't say that at the beginning, and I am so grateful for having been invited to participate in this you know, panel discussion. It is always a pleasure to connect back with the Center for Human Rights, which we always consider home. So thank you so much once again.
Thank you so much, Honorable Justice, and we are also grateful that you accepted our invitation. Yes, Council Wesley.
Thank you so much, Owor, and I'm also grateful to the Center for inviting me to this webinar. And I hope my brief presentation would also encourage other lawyers to take up strategic public interest litigation. And for anyone who is going to take up any case that deals with a freedom of expression or access to information, I'm always available. Get my email and email me, and I'll be more than happy to help for free in terms of strategies and so on and so forth. And otherwise, I'm grateful that I was part of this panel and that you invited me. It was an honor. So thank you.
Oh, thank you so much, Honorable Commissioner. Thank you so much, Wesley. Honorable Commissioner has left the meeting as she has gone for further engagements. Please, if you have further questions to her, you keep following up to our emails or on the social media platform. As we come to the end of this wonderful webinar, I would like to say I have a very key take-home that each of us should have at the back of our mind. One very clear take-home is that the Constitutional Court of Malawi's decision to decriminalize defamation is not just a legal victory for Malawi alone, but a democratic milestone that the entire African continent should celebrate. And it's a reminder that courts in Africa can be bold protectors of freedom of expression in this digital age. And following this webinar, we call on all the other African countries to adopt the same. But our conference today also shows us that this ruling is not just an end in itself. It's an invitation. An invitation to lawyers, activists, journalists, and ordinary citizens across Africa to push back against repression, to defend digital freedoms and rights, and to reimage what true democratic expression can look like in Africa. The case has already been set clear in Malawi, and we can all ably follow that suit. Let us not allow this dialogue to end here. I encourage all of us to keep these conversations alive in our own spaces, especially on social media, Twitter, or Facebook accounts, among many others, where these freedoms are most under pressure. Let's share the lessons to our colleagues, family, and friends, challenge the narrative, and continue building a movement that ensures that freedom of expression in Africa is protected and not silenced. Finally, on behalf of all of us, I would like to extend a heartfelt thanks to the Center for Human Rights of the University of Pretoria for organizing and supporting such an important initiative. The Center's work continues to remind us that human rights is not an abstract ideal, but a living commitment that must be defended daily and with all the efforts of our life. To our distinguished speakers, participants, and everybody that joined us today, thank you so much for your contribution, your insights, your questions, and your passions for attending this important webinar. Together, we leave this webinar with renewed energy to ensure that the promise for digital freedom becomes a reality in Africa. Please stay engaged, stay encouraged, stay tuned to the Center for Human Rights website for webinars like this, and let's continue this journey. Well, I leave the floor back now to Belinda to take over from here. Thank you so much.
Thank you so much, Kennedy, for hosting this. You did a fantastic job. And thank you to all the panelists for the amazing contributions. And to my take home from what Judge Kapindu said was how we are quick to reference the global north and forgetting that we are surrounded by other African countries that are having cases like this or judgments like this that affect us, and they are also changing the African narrative on how we perceive things going forward. So for us to take a look at what's happening within the countries around us, and usually I personally reference South Africa and Kenya, and I forget that we have other several African countries that are also doing amazing things. So thank you all for your contributions. And if there's nothing from anyone within the center who wants to contribute, I think this is the ending. Yeah, I don't think anyone is contributing anything. So thank you all for joining, and until next time, goodbye.
Thank you. Goodbye.